Supreme Court of India Wadla Bheemaraidu vs State of Telangana decided on December 3, 2024 INSC 923 facts of the case. As per the prosecution case, K. Nagesh, the deceased, and Srimati Shivalila alias Wadla Anjali, wife of the appellant herein, accused number 1, developed an extramarital affair with each other. On 7 January 2013, they eloped from their village Thipraspally, district Rangareddy, Telangana. Shivalila at Wadla Anjali returned to the village after 4 days, but K. Nagesh failed to turn up. It is further the case of the prosecution that the appellant, accused number 1, was not satisfied with the above resolution and thus, he hatched a plan to eliminate K. Nagesh. On 19 January 2013, the family members of the deceased, on a demand made by the accused persons, paid a penalty of Rs 3,50,000 to the appellant, accused number 1. The missing person complaint was converted into an FIR for the offences punishable under sections 384, 364, 302, 201 read with section 109 IPC. Trial court proceeded to acquit accused number 4 to accused number 8 of the charges. Accused number 1, the appellant herein, accused number 2 and accused number 3 were convicted. High Court reversed the conviction of accused number 2 and accused number 3 and acquitted them while affirming the conviction accused number 1. Findings of the court: there is no dispute that the case of prosecution is based purely on circumstantial evidence, since no witness claims to have seen the alleged incident wherein K. Nagesh, the deceased, was murdered. Firstly, we proceed to consider the theory of motive. On going through the entire evidence led by the prosecution, we do not find an utterance of a single word by any of the prosecution witnesses, including the mother of the deceased, prosecution witness 1, the father of the deceased, prosecution witness 2, that there was any complaint of an illicit affair between K. Nagesh, the deceased, and Srimati Shivalila, the wife of the appellant. The prosecution alleged that owing to this illicit affair, the appellant got convened a panchayat wherein he demanded and extorted a sum of Rs 3,50,000 from the family members of the deceased. However, such a suggestion was totally denied by prosecution witness 1 and prosecution witness 2. Both these witnesses stated that it was the chit amount collected by their son, the deceased, which was paid by them. Further, on going through the testimony of the investigating exhibit P22, A26 exhibit P42 officer, prosecution witness 22, we find that even he did not state that any information was provided to him regarding the so-called illicit affair between the deceased and the wife of the appellant, prosecution witness 8, during the entire course of investigation. The only evidence provided regarding this aspect of motive, as per the testimony of investigating officer, prosecution witness 22, was in the form of a photograph, exhibit P37. However, the fact remains that even the parents of the deceased, prosecution witness 1 and prosecution witness 2, were not made to identify this photograph. Thus, the theory of motive attributed by the prosecution to the accused appellant could not be established by any credible evidence. The second and most vital link of circumstantial evidence sought to be relied upon by the prosecution was the alleged discovery and recovery of the skeletal remains of the deceased in furtherance of the information 27 provided by the accused appellant, accused number, to the investigating officer, prosecution witness 22. The law is well settled by a catena of judgments of this court that the information under Section 27 IEA which leads to discovery of an incriminating material evidence must be proved by the investigating officer as being voluntary and uninfluenced by 27 Exhibit P22, A. Investigating officer, prosecution witness 22. Version of prosecution witness 22. It can clearly be discerned that neither did the witness narrate the words spoken by the accused regarding the place of concealment of the dead body of K. Nagesh, nor that the said fact/place was exclusively in his knowledge and that he could get the same recovered. Rather, there is a very startling fact which is evident from the aforesaid extract of the investigating officer's evidence, inasmuch as the investigating officer did not utter a single word that the accused also accompanied him and the panch witnesses for pointing out and getting recovered the skeletal remains and the clothes purported to be of the deceased. The testimony of Dr. Syed Irshad, medical officer, PW 15, who also admitted in his cross-examination that police and other persons had shown him the skeletal remains. The panch witness, prosecution witness 9 and prosecution witness 19, also did not make a whisper regarding the accused, leading them to the place from where the incriminating articles were recovered. Have no hesitation in holding that neither was the disclosure allegedly suffered by the accused before the investigating officer. Prosecution witness 22. Under Section 27 IEA proved as per law, nor did the prosecution establish that the discovery was made on being pointed out by the accused. Since the very factum of the discovery/recovery of incriminating skeletal remains was not proved by proper evidence, the same cannot be linked to the accused appellant. The third link of circumstantial evidence is that the recovered skeletal remains were purportedly matched with the blood of the mother of the deceased, prosecution witness 1, by the process of DNA profiling. However, as has been noted above, prosecution witness 1 did not utter a single word that her blood sample was collected by the investigating officer, prosecution witness 22, during the course of the investigation. Also, even Dr. Syed Irshad, medical officer, prosecution witness 15, did not state that he collected the blood samples of prosecution witness 1. Thus, the DNA profiling report pales into insignificance and cannot be treated as an incriminating circumstance against the accused. We have no hesitation in holding that none of the incriminating circumstances Exhibit P-42 portrayed by the prosecution in its endeavor to bring home the charges against the accused appellant were established by cogent and clinching evidence, and therefore, the conviction of the accused appellant as recorded by the trial court and affirmed by the High Court cannot be sustained. The appeal is allowed accordingly.